The April data protection webinar on global data protection. And again, it's a double act, as like the January webinar was. So for those of you that don't know me, I'm Kelly Peters, one of the co-founders of Databasix. And hey, I am joined by my awesome co-founder, Regina.
Hi everyone, good to be here.
Cool. I will, if anyone's interested in a copy of the slides, type it in the chat box and I'll make sure that you can get a copy of the slides sent to you afterwards. As is always the case with our webinars, there will be a recording that will be made available on our YouTube channel and via our website early next week. Feel free to ask us any questions in the chat box, and what we'll do is, if we can build them in as we're talking, we will do. If not, we'll come to them at the Q&A section. So we've got quite a lot to cover today, and I did get a little excited when I was writing these slides, I'm not gonna lie. So I suggested that we were going to talk about China, Canada, United States, Switzerland, Singapore and New Zealand. And as you can see, New Zealand's not on here because I've only got 45 minutes to chat, and I thought that if I added New Zealand here, you would never get a lunch break. So, soz. What we've also built in is top tips and a checklist, and there is time for questions. So, quick question for everybody on here. Is there anything that's particular of interest to you, a particular country or a particular international data protection question that you have of mind that you'd like us to see if we can tackle? Type that in the chat box whilst I show you a very awesome map. So we routinely use a number of resources available to us from law firms, and I've sourced this one here. So this is a global map of data protection across the globe, and as you can see, there ranges from very heavy regulations, of which Europe sits within the dark red, all the way to limited. And as you can see, some of the African countries in South America don't have as much data protection as some of the North American, European countries do. So if you are interested, I would highly recommend that you do look at the DLA PIPL data protection website. They have a fantastic tool that allows you to compare the country that you're interested in entering and the country that you're currently in to do a comparison. So I know Regina and I have used it, so do use it. Good. So I can see that the states are an important area, so we'll make sure. And insight on India, excellent. So that is something that we might need to come back to you on, but I do know that there's a lot of companies that have their processing activities in India. So if you can bear that in mind, we will come back to you on that. So let's first talk about China. So China has the Personal Information and Protection Law. So prior to introducing this piece of legislation, they had the data security law and the cybersecurity law. So what they now have is these three pieces of legislation that work well together. Now, my first point to say to you is if you are already adhered to the GDPR, then you will be in a very good position to be able to handle the requirements that are set out in the PIPL. That's not to say that you'll be 100% compliant. There are some nuances. Now, this piece of legislation came about whilst we were in the midst of dealing with COVID, but it is now in effect. So what does that actually mean to you and your organisations? So there are 4 official goals of the legislation, which are set down here. So it is about protecting the rights and interests of individuals. It is about regulating personal information. So they don't talk about personal data, they talk about personal information. And that's a nuance because we talk about personal data in Europe and the UK. It talks about safeguarding the lawful and orderly flow of data. And we will talk about the expectations that the Chinese government have on organizations exporting data from China to elsewhere, and facilitating the reasonable use of personal data. So you can see there's a slight difference in terms of their goals of what the law will do. So this is where it is similar to the GDPR. So you'll know from experience with the GDPR is that it has extraterritorial scope. So what that means is that you don't have to have a physical presence in the UK or Europe for the GDPR to be applicable to you. And that is exactly the same in China. So if you are based within China, then obviously the law applies to you. It also applies if you are outside of China. However, you are processing personal information on Chinese residents. So it is very important to know that if you are looking to enter into the Chinese market and you are going to be collecting information on Chinese residents, you have to be mindful of this piece of legislation. So you'll need to comply with the law in China if you're providing products or services to domestic natural persons, which I quite liked. If you analyze or evaluate their activities of domestic purposes, so if you think about what we talk about in terms of evaluation and monitoring activities, this is analyzing and evaluating. And there is the final bullet point, which I'm still trying to get my head around as to other circumstances as provided by laws and administrative regulations in China. So if something else comes up where they have introduced a piece of legislation, they might reference the expectation that you comply with the PIPL. So big thing, as just to keep reinforcing, if you are going to be providing products and services to China, regardless of whether or not you're based in China, you do need to comply with this law. What is personal information? Now, what I liked about this particular piece of law is it does define anonymization. So personal information is all information related to identified individuals or identified natural persons, unless it is anonymized. And what they mean by anonymized is that there is no way that you can go backwards, so reverse that anonymized data and re-identify somebody. So we talk about pseudonymized information, where you could have two pieces of information, whereas they were combined together through their kind of unique codes. By linking them together, you could re-identify the data. So it's not fully anonymized. What we're talking about here in anonymized information then is that there is absolutely no way that you could identify that individual. So the law doesn't apply if you're genuinely processing anonymized information. There are 5 basic principles. So whereas in the GDPR we have 6 plus accountability, we have 5 here, including accuracy. We have 6 legal bases, and what is really interesting in here is that whilst they do have consent, they do have a legal basis that relates to human resource management. So where we talk about contract or legal obligations such as employment law, they've specifically referenced this. They do identify sensitive information as including financial data, whereas within the GDPR, financial information typically falls under the category of personal data. And for us, it does not. It's sensitive information in China. But China also has included biometrics and medical and health information. Now, they have real strict provisions on place in terms of international data transfers. So if you are going to be exporting data from China to any other country outside of China, you have to do a risk assessment. And you need to be able to determine that the place that you're transferring data to has adequate provisions in place to that of what is dictated within this piece of legislation. And you cannot transfer data unless you've done that risk assessment. So they are very much, don't transfer it unless you've done the risk assessment. So don't transfer it and think you're going to be okay. Please do the risk assessment. So it's no different in GDPR, where we ask you to conduct a transfer risk assessment, and you're assessing the appropriateness of data protection legislations in other countries. So use the tool that I've showed you just a moment ago from DLLP PIPL and look at what is comparable and assess, is this a good place to be transferring data to? So my top tips for dealing with Chinese data protection is to conduct a gap analysis. If you are compliant with GDPR, compare your GDPR provisions that you have in place to what is required under the PIPL, and then put in place those missing gaps. And it might be that you don't have the international risk assessments that are specific to China. It might be that you don't have all of the appropriate references in the privacy policy that relate to personal information rather than personal data, for example. And there is a requirement that you appoint a representative in China where you have no physical presence. So it's very similar to an EU representative. So they're my top tips for interacting with Chinese data protection. So we're going to fast forward and travel. We are moving forward in time, aren't we? America is ahead of us, is behind. Well, there you go. I don't even know time zones. Boo. So a little bit of light-hearted entertainment Kelly doesn't know in the world where we are on the timeline. So Regina, I'm going to hand over to you to talk about American data protection.
Excellent. Excuse me, sorry. So yes, the states have had some kind of data privacy in place for some time, as you can see there on the timeline. And it started out looking sort of more at government level privacy, and then has sort of moved and expanded into other areas, sort of obviously with a focus on health. And when you look at it now, it is very piecemeal compared to kind of like the unified legislation that we have. We have different aspects in terms of obviously GDPR and data protection. We've got privacy electronic communications regulation where the two link in, and then specific things around computer misuse. But this is even more piecemeal in that there's no one overarching set of legislation like GDPR that applies uniformly across the United States. It's kind of got almost a state-by-state approach. So the 1999 one, the Gramm-Leach-Billy Act, Blilly, that rolls off the tongue, doesn't it? That protects sort of financial information, and then bearing in mind the shift in terms of online and the growth of online around the early sort of turn of the century, that's then very much looking at how you can protect children when they're interacting with the internet and acting online. So that's the COPPA legislation. So they've got all these various different focuses, and then what we've been seeing over the last sort of few years, led largely by California, has been an introduction on a state-by-state basis, which we'll be looking at in a second. You've got, again, various different people that can look at how you're complying. The Federal Trade Commission can look at organisations and how they're complying with data protection legislation and the different elements around their security legislation. And one of the key things that they can look at, that I think it's reasonable to make sure that if you're working in that market that you need to review, is whether you are being truly transparent and honest within your privacy policies about the nature of the security measures that you have in place and what you're doing to protect people's data. If you make inaccurate statements in those privacy policies, and around the security measures, around how you handle people's data, they can look to penalise you for that. So if you have been using templates, for example, that you haven't really necessarily checked through to make sure that they apply to your organisation and what you do, then make sure that if you're working or moving towards working in the US market, that I obviously advocate that you should do that for here anyway, but make sure that what you're putting out there on your website is accurate and it reflects truly what you're doing, because they will look at whether or not you are being truthful and honest in the measures that you have in place. When we then look at this is from another law firm that has provided this very nice map. The source is on there. It's very helpful to see it visually as to what the spread of data protection legislation is across the different states. And so you can see it's not one uniform approach. So anything where there's grey, there's no bill proposed, there's nothing in place, so they would only be subject to those federal level pieces of legislation that we talked about at the beginning. You've got then some that have got very active and enforced legislation that's sort of at the other end of it. So the yellow states there, like California, which I think probably most of us are aware of the fact that California have often led the way in terms of that. It's been enacted, it's enforced. And then you've got legislation that is in place, and then you've got some that's being updated where it's passing or not passing or going through the various houses and legal machinations within the US to get bills passed. So there's a lot of different, there's similarities across them all. Some of them are quite linked to GDPR, others are less linked, and you might need to be more aware of differences. But I think it's key that you can't see the United States as one sort of single market. It's important to know, well, where are you particularly targeting, where you're anticipating that you're going to be processing data of those residents. A lot of them will always be focused on their residents, and then being able to make sure that you can do those checks and see what the slight differences are again, in where you might need to focus and tweak what you already have in place. So we've picked up with a couple of the key ones where they've got it in place and it's enforced. So as I said, the California Consumer Privacy Act, the CCPA, that came into effect back in January 2020, and that looks at organizations that do business in California, so targeting their residents, and that also gives people the chance to, through civil litigation, to actually take those companies to task around the way in which data is used. So that's quite an interesting addition for the sort of, it's not something that we've seen so much here. We've started to see a little bit of that class action suits coming through that was enabled through GDPR, but I think we've got a very different culture here this side of the Atlantic, where that's not necessarily the first port of call, whereas obviously stateside it is much more, litigation focused. And so if residents have got that ability to take companies to task, then they're probably more likely to do it. So it is very specific, and that's, I think, what you can see when you look at the different states, that they're targeting bigger businesses or businesses that are processing large volumes of data. So again, it might not necessarily be something that applies to you when you look at the volume of records that you're processing about individuals, but it's important that you do that check, and also then keep an eye on, if it's not relevant at the time you're moving into that market, then as you grow, is it something that then becomes relevant and that you need to think about? Obviously, again, there will be elements that you can look at putting in place ready, and complying with GDPR will put you in a good stead for a lot of the different requirements, but there are often some tweaks that you need to make sure that you have in place. So you can see here with California, it's looking at organizations that have revenue over $25 million, or that they're processing personal data of more than 50,000 individuals, and that is of California residents, or they get more than 50% of their revenue from selling personal data. And now the California, in terms of the what they term of sale of data, it's not necessarily monetary, sort of what we would see as sort of what a data broker does, that you're selling lists of data, or that you're selling the insight and profiles, maybe if you're something like a loyalty card company where you've built up all the insight into the nectar purchases of your those individuals that you then sell on to other organizations to have that insight. They are very, very broad in their definition of what they class as sale of data. So they include selling, they include renting it. So if you were to give people temporary access, releasing it, so sort of putting it out there, disclosing it to other organizations, and it's making it available to other organizations, or disseminating it to organizations. And basically, if you are looking at getting any, not necessarily monetary return, but if there's also a valuable consideration in what that organization will get from you sharing that data with them, then that would be considered for as a sale in terms of this. So you need to be careful of Things like that it will affect most organizations is if you're using things like Google Analytics, Facebook Pixel, all the cookies, you know, you're collecting and seeing that information, but it's obviously going to be going straight to Google, straight to Facebook as well. They will have that sort of more aggregated data that they can also use on a larger scale. And so therefore you need to think about actually in that's being transferred, it's being disclosed to Google, Facebook, whoever. They are then getting valuable insight. They're getting a return on that, even though it's not a monetary thing, because you're, you know, they're not necessarily, you might be paying them for Google Ads, they're not necessarily paying you for that data. However, they are getting insight and benefit from it as an organization. And so therefore you have to make sure that you manage that ability and that, you know, and typically you can do that through the cookie consent model, but to make sure that you're giving people that choice that, you know, you do not sell their data, bearing in mind that broader definition. Excuse me. So moving on then to Colorado. Again, you've got the concept of a controller, so organizations that are responsible for the data, and they are very much looking at intentionally targeting the residents of Colorado. And again, they've got thresholds here. So the thresholds for whether or not you need to be worried about the Colorado Privacy Act is that you are processing, it's consumers rather than all individuals. I'm really sorry, I'm just going to have to take a break. Kelly, can you pick up?
Yeah. So again, what we're talking about here is volume of personal data of 100,000 consumers. So whereas in GDPR, we're talking about all types of individuals, it's very consumer driven, which is what the majority of state law data protection in America is. And again, very much like the California Privacy Act, it's about deriving revenue. And you'll see that this is a lower amount than what was in California. So as Regina alluded to previously, you need to understand state by state the different variances and thresholds that you have to adhere to. So again, this is about the sale of personal data, but it is of 25,000 or more consumers. So it's a lower threshold than that of California. So there is a marked difference, though it's still consumers, it's a lower threshold.
Thank you. And so with the definitions there, what we're looking at is consumers are looking at people who live in Colorado, and it's where it is within their own sort of environment, or it's within a household context. So it does exclude any business related. So if you're business to business, you would not need to worry about this particular element. It is very much private residence. As Kelly mentioned, you've got the opportunity, or they've got the opportunity as Colorado residents to opt out of the sale of their personal data. I think the definition within Colorado is less broad than it is in terms of California. California is the broadest, but again, it's worth being really clear about what they mean and how they pull that through. And again, then it's with some of the states, it's the Attorney General that will have the right to look at bringing enforcement actions. California, for example, has its own regulator now that's been introduced relatively recently, and they I think that may then look at, we may see an increase in the level of enforcement in California because they've got a specific organization that's focusing on it. And then if we look at Virginia, so again, this is very, very similar. It's only just come into effect in January 2023. And again, we've got the thresholds, and these are much more similar to Colorado than they are to California. It's focusing again on consumers who are resident in Virginia, and so you're looking at the threshold here is 100,000, and again the definition here is around the collect, use, or disclosure of personal information. So you're looking at you need to consider those different definitions when you're looking at this on a state-by-state basis, and again it's looking at how you make the money, make your revenue, or where you get your revenue from. And this is very, again, it's a slimmer definition of sale than in California, but it's you need to be aware of what they constitute as a sale of data, so that you can make sure that your revenue isn't being driven by that sale in relation to what you're making, and then whether or not that means that you would then fall under the need to comply with this particular law. Again, what this Virginia brings in is that right of access. So some of them have pulled through some of the elements of data protection elements from this side of the Atlantic, and they can actually request it to be updated if it's inaccurate. So again, strengthening the individual rights of people within the state. So that's there's a lot to cover across all of those different states. So we can only do really a whistle-stop tour. What I would say is that if you are working in the United States, if you're entering that market or currently there, do go through, use some of those tools online, and have that sort of check around what are the differences, what are the thresholds, what's in place already that you need to make sure that you're working within. Do you hit any of those thresholds? And if you do, then start looking at, okay, what do we need to put in place? Most of the states ask that they include a do not track. So that means that when it's that sort of cookie approach again, so that you're not tracking their activity over and across other websites, you're not tracking them. And so you have to make that request easy. Again, if you put cookie policies and have an effective cookie management tool in place, that is often the best way, and you can explain it to them about how they can fulfill that do not track section. And similarly, a lot of them will have a do not sell requirement, and you can see this in privacy policies around the world where they are working, particularly in California or other areas, and they will have a very clear statement about how you can make it clear that you do not want the sell in place. And so making sure that that's included again. You can't control where people come to on your website, so if you're working in that market, do look at the different requirements across all the states and make sure that you've got something that will cover you for the states in your privacy notice, and that it is up to date and reflective of your actual activity. So for me, the main thing to sort of start looking at would be your privacy policy as a good first step if you're in the US market.
Marvelous, thank you. So we're going to move slightly north now and go to Canada. So Canada has had a Privacy Protection Act in place for quite some time. It was the Personal Information Protection and Electronic Documents Act. A lot of the privacy by design and by default from this country has come from Canadian professionals when they were designing this. So we have taken a lot of that privacy by design and by default from Canadian privacy regulations. Now, what the previous legislation, and the one that's still in force because this is only in draft at the moment, was very much about personal information and didn't really cover sensitive data. So as with all of the data protection that we are looking at, they are acknowledging that the world has shifted and moved on from where the original piece of legislation is, and that they need to become more modern with the law that it's trying to introduce. So the Digital Charter Implementation Act will introduce, by the Canadian federal law, this Consumer Privacy Protection Act. It will also bring in some cyber security legislation as well, very similar to what is going on in Europe as well as in a number of other countries across the world. Now, it defines personal identifiable information, so it's not personal data. But if you're eagle-eyed, you may have noticed that this is any information about identifiable individuals living or deceased. Now, that is very different to what we have across Europe and the UK, because we are talking about living natural persons. Whereas if you are working in Canada, you have to be mindful that if you're processing information on deceased, and you may do if you get notified that a consumer has died and you've updated your database accordingly, you will be processing that data. It has information that includes opinions like what we do. It has a very employee focus, even though it says it's a consumer privacy protection. There is employee elements in this because there's disciplinary actions, there's employment files, there's credit records, there's information about disputes between a consumer and a merchant, and in particular the intentions to purchase goods and stuff. So it is a broader definition of personal information than what we have in this country, because we don't really talk about the existence of disputes, although in terms of employee records we do have information about disciplinaries and grievances, for example, as would be the case in Europe. So quite a lot of information is classed as personal data. It does require that if you collect, use and share personal information for commercial purposes, then this piece of legislation will apply to you. And it also applies, and it's very clear that it applies if you have employees or job candidates. So I quite like it's being specific about the subject, who is the subject of the data that you're collecting. So it's not yet come into force because it is in the draft stage, very much like what's going on in the UK at the moment. It will be critiqued, it may be changed, but do be mindful that if you are in Canada or you're looking to enter the Canadian market, that they are looking to change their legislation. So what you need to make sure that you have in place is that you have appropriate technical and organizational measures. So if you take what Regina said about America and the Federal Trade Commission, where they can impose penalties for non-compliance or not being secure enough with the data that you're processing, Canadian law very much wants you to make sure that you have the technical measures to protect personal data. And in particular, the materials that they expect you to produce include how you train your staff, how you manage individual complaints and rights, and really protect personal information. So if you adhere to GDPR and you adhere to the accountability principle, a lot of this will not be new to you. It should be adaptable to the Canadian market, but they very much want, it's not enough to say you do it, they want you to evidence how you comply with that security, both from a technical, physical and organizational measure. So do bear that in mind. So let me just, we've still got time. I'm doing okay so far. What we then have is we're going back around and we're going to go to Singapore. So Singapore has introduced the Personal Data Protection Act in the 1st of February 2021. Again, it feels like a lifetime ago, but the world has changed a lot in that 2 years. It very much talks about regulating the collection, use and disclosure of personal data in Singapore. And again, like GDPR, like the new Chinese legislation, it doesn't matter if you don't have a home base in Singapore as a company. If you are processing personal information on Singapore residents, then you have to apply this legislation to your processing activities. It talks about whether or not data is true or not. So if you've got inaccurate information, there's no surprise that there is an accuracy and the right for individuals to request that their data is accurate. But it does require you to know that you can identify individuals, whether their data is true or not, and other information which the organization has or is likely to have access to. And so some of those examples of what is personal data includes cookie identifiers. So we might not have a name on a cookie, but we'll have a unique identifier that you can track back to somebody. Email addresses, so full names, for example. Gender and political and religious convictions, very similar to what we have over in Europe. So you need to be able to know the data you're going to process on Singapore residents. If it meets the criteria of personal information, then you need to be mindful that you're complying with this. Now, at a user's request, so if an individual in Singapore asks you about what information you process on them, you have to tell them. That shouldn't be something that is unfamiliar to any of you on this call. You have to disclose how you have used their data within the year since. So they make the request now. So how have you used the data in the last year? and you have to rectify any error or omission. So very much like we have the right to rectification, they also have enforced this. So if information is incorrect, a Singapore resident has told you it's incorrect, you must have processes in place to be able to make that correction. So I think hopefully what you're getting so far from this, and we've still got one more country to go to, is that your transparency statement that you're going to have in the form of your privacy policy is really critical to be able to explain to people about what you process, why you process, how you process that, where you share information to, what the individual rights are to those individuals. Now, you may, if you are a global organization, you might want to have ways in which people can quickly switch from maybe the UK GDPR to a state in America to maybe the Singapore, so that it's easy for an individual to navigate to the appropriate section of that privacy policy. They do, very much like a lot of data protection legislation, expect you that if you're going to transfer data, you're going to export it from Singapore to another country, that country has a comparable data protection regime. So you need to do that check first. You can't assume it's okay to do that. So you do the risk assessment on that international data transfer. And what's of particular interest here is if you have a breach, so under GDPR, we have 72 hours to report a breach once we become aware of it. The requirement here is users and the Data Protection Commission in Singapore. So it's not just the commissioner. You do have to notify individuals as well, whereas we get a bit of an opportunity to determine what's the risk to the individual before we disclose what the breach is. So that's Singapore. Let me take a brief breath before I do the very final country that we're talking about, and that's the Switzerland. And they have introduced a new piece of legislation which comes into effect in September this year. So if you are operating in Switzerland, you've got a little bit of time to prepare for this. So like previous legislation, they've had to modernize. Their act was 1993, so it's 40 years. Is that right? No,
30.
30, thank you. I was like, that's wrong. So I don't, so not only do I not know time zones, I can't do maths on this Friday webinar. So 30 years on, the new piece of legislation has to reflect the digital world that it works in. If you intentionally breach the law, then they can fine you in Swiss francs up to 250,000. And they have now expanded their definition of sensitive data to include biometric and genetic data. So it's interesting to note that they've expanded the scope, very much like GDPR did. It gives more rights to individuals, and we're going to see this more and more in data protection across the world, is that individuals will have greater rights over how their data is being processed. So individuals have the right to have access. They'll have the right to deletion. They'll have the right to intervene. If you're using automated decision making, they'll have the right to be able to talk to a human being rather than just assuming that the algorithm is right. So it is similar to what we have. So you need to make sure that you can reflect these rights and that you have processes in place to be able to respond to these rights of individuals within Switzerland. Now, it is mandatory for you to disclose information on recipients, so anyone that is in receipt of the data that you are processing. You have to perform processing impact assessments. So you have to complete impact assessments on high risk processing. So think about the sensitive data as defined by the Swiss government. Think about the volume of the data that you're processing and the activities that you're undertaking. Is it evaluation? Is it monitoring? So what is the high risk activities? And complete an impact assessment. Again, if you already do this for GDPR, you're going to be in a very good position to be able to handle this new piece of legislation. And very much like all the other pieces of law that we've talked about today, you need to be in a position to be able to notify the relevant authority when a breach occurs. And they do expect you to have reasonable measures in place to keep data safe and secure, particularly when it comes to handling sensitive information. So the final top tips that I have before we open it up to any questions, so start thinking about the questions you might have for us, is clearly describe your processing of personal data in your privacy notices. So if you're going to be processing information on Swiss residents, make sure that your privacy policy reflects that. Make sure you have processes in place to be able to know when you've had a breach and know when to report it to the Federal Data Protection and Information Commissioner. And do conduct data protection impact assessments on your high risk data processing activities. So they are our top tips for Switzerland. Are there any questions?
While you're thinking about that, there's one more top tip for the
Oh, go for it.
Switzerland and Germany area. They both require, if you're doing marketing to those areas, for email marketing, they require double opt-in for consent. So it's not, that's seen as best practice here, but you can have single opt-in. Whereas for Germany and Switzerland, in terms of marketing information, because they've got a specific law about the Act Against Unfair Competition, which regulates their marketing activities, and both those areas, they expect you to have double opt-in. And in Austria, definitely don't email anybody if you haven't got consent, because they won't like it at all.
Well, throw in a few bonus points there, Regina. I like it. I don't see any questions. Does anybody have any questions for us? It's okay if you don't. I know that we've given you a lot to digest today. So if there aren't, Regina.
I was just going to say, I think it's one of the interesting things sort of in the blurb around this is around in that initial map is how much of the world is covered by some kind of data protection legislation now. So I think it's almost, if you are looking to move into any new markets that are outside of the data protection zone that then do see what's there. I've got sort of some very top level things around, particularly things like the United Arab Emirates. They have very specific elements around financial data and how that links in, and marketing in those areas. So really thinking and understanding the different data protection regimes, how that impacts on your processing, the communication you'd have in place, and things like your marketing activities will be really key in terms of your preparation of moving into that area and that market, because some enforcement areas are stronger than others. And so, the likes of the German speaking world in Europe are much more strict than, say, we might be here, and we might be more strict than certain places. But all around the world, there is more and more legislation coming in that covers how people's data is used. So being aware of that, if you are looking to have international markets, whether you are going to physically be there or you're just processing the personal data of people from that area, it's really important to understand what your obligations are from a data protection perspective.
Boom, like it. So in conclusion, then what I'd say is do keep in touch with us. Keep an eye on our website. We'll have this webinar and lots of other cool infographics and blogs that might be of interest to you. Send us questions to our info@ email address. Connect with us on LinkedIn. Subscribe to our YouTube channel so you'll get to see other videos that we have available. Feel free to subscribe to our newsletter. Next month, Regina and I will be talking about the proposed changes to UK data protection. So mark that in your diary. It'll be the final Friday of May. And if there are no questions, I'd just like to thank you for listening to me and Regina give you a whistle-stop tour. Here you are.